Hello, I'd like to welcome you to today's eNATOA on right-of-way control and compensation. My name's Brian Roberts. I'm a policy analyst with the City and County of San Francisco. I'm also a member of the NATOA board and co-chair of the Community Broadband Committee. I'm joined today in our meeting room here with Bill Sanders of our City Attorney's Office. And today we have a great set of presentations about right-of-way management by Gerald Lederer, Ken Fellman, and Brian Grogan. Jerry is a partner at Best Krieger Municipal Law Practice Group. He advocates for public and private property owners regarding issues of law and policy arising from federal and state communications legislation and regulation. Jerry serves as legislative counsel to Telecommunity, a collection of local governments dedicated to ensuring respect for local rights in federal legislative activity. He is one of the nation's leading authorities on marketplace solutions for the integration of technology into commercial real estate. He authored Critical Connections and Wired for Profit, two leading guides on the integration of telecommunications technology into office buildings. He developed the first model license agreements for access to buildings and rooftops to help telecommunications service providers and property owners protect their interests. Jerry was the 2011 NATOA Member of the Year. Ken Fellman is a partner with the Denver law firm of Kissinger and Fellman. His practice emphasizes local government representation, particularly telecommunications law. Ken represents local governments nationally in connection with cable matters, community broadband deployment, and public safety communications. Ken served as mayor and city council member for Arvada, Colorado from 1993 to 2007, appointed in 1997 by then FCC Chairman Reed Hunt to the Commission's Local State Government Advisory Committee. He served as chair until the FCC disbanded the committee in 2003. Ken is a NATOA board member, or has been, has testified on NATOA's behalf at the U.S. House and Senate. He was honored as NATOA's 2006 President's Award and chosen as the 1998 Member of the Year. Ken also served on the Intergovernmental Affairs Committee, representing city attorneys on that committee. And that's currently in abeyance, but we hope it'll be reviving again shortly. Brian Grogan is a shareholder and director with the Minneapolis law firm of Moss and Barnett, practicing the firm's communications, business law, and infrastructure practice groups. Since 1988, Brian has worked with entities throughout the country on a variety of cable, telecom, wireless, and broadband communications issues. In his business law practice, Brian focuses on fiber and conduit lease agreements, mergers and acquisitions, and contract matters for the communications and technology interests. Brian is past chair of the communications law section of the Minnesota State Bar Association. So we have quite a distinguished panel today, and they'll be speaking in that order. Each of them will have a presentation. But before we get started on that, I had some interest in the NATOA conference, and quite a bit of interest was expressed in the city's recent victory in a lawsuit filed by T-Mobile and others, the others being Crown Castle, NG West, Extenet. And it was regarding some an ordinance that the city had passed requiring a permit for wireless facilities on, essentially on utility poles in the right-of-way. And the state of California has a very restrictive law that gives licensed telecommunications providers a lot of latitude in terms of the access to the right-of-way. So it's restrictive in the sense of municipal control of the right-of-way. So one of the interests in San Francisco was aesthetics. So emphasis of our ordinance was that we wanted to control for the aesthetic impact of wireless facilities. And the ordinance was passed in 2011. We were sued by the carriers, essentially on the grounds that aesthetics were beyond the scope of what we could regulate carriers for. We were really limited just to kind of ministerial time, place, and manner kinds of decisions. And there was another piece of it that had to do with construction, differing requirements between wireless carriers and other types of carriers. We prevailed initially, and that decision was appealed, and this latest decision from September 15th upheld the initial decision, upholding our ordinance, especially with respect to those key items of the ability to regulate for aesthetic issues. And I'm joined here by Bill Sanders, who can kind of elucidate on my rough outline and add any kind of nuance there.
I think Brian did an excellent job. I think the gist of the state law here is that carriers get a franchise to be in the public rights of way, subject to local regulation against incommoding the use of the public rights of way. And this is a law that many states have similar versions of it. You know, it was sort of maybe one of the first instances of corporate lobbying. And the gist of the issue in the case was, what does incommode mean? The carriers argued that incommode just means obstruct, and we argued that it's much broader and it extends all the way to the court agreed with us that incommode is a broad term and allowed us to regulate for aesthetics, at least from a facial challenge. Whether they ever challenge our individual citing decisions saying that we've gone too far in our regulation, we don't know. But we won on the main issue, which is, can we regulate for aesthetics? And that's the gist of the holding of the case.
Thanks, Bill. And I think we'll get to our three presentations now, and we'd like to, we'll be looking as you enter questions into the webinar system, and we'll be allowing some time at the end of the session to respond to those questions. But we'd like to get through, we have, again, three very informative presentations. We'd like to get through those. So to start, Jerry is going to set the table and talk about, give us a general framework of the issues involving right-of-way control and compensation. Jerry?
Thanks so much, Brian, and I hope everyone can hear me and that my presentation is up on the screen. Actually, I've never gotten a chance to do this. I thank you for mentioning that I was the Member of the Year in 2011. I've never done a program with Ken where I got to thank him. He was our president at that time and gave me that honor, and I'm absolutely grateful. Look, I'm not going to kid anybody. I'm going to talk too fast, and we're going to fly through this because this is a classic case of probably we have bitten off much more than we can chew. And I think so what I'm hoping here to do is to sort of establish what the questions posed are, to at least cite people to the rules that might be involved, and then to go and see if we can't start to have some of the answers. So what's changed? I mean, why is this presentation so much different than, you know, we've talked about in the past? I mean, we've all been around for quite some time. What's happened that is now making us rethink about compensation for use of the rights of way and overall management of the rights of way that hadn't been an issue that we've had since sort of 1984 or so? And I think the answer is two major things have happened. One, in the FCC's open internet order, they determined that internet access services or broadband access services were no longer purely interstate information services, but that they are also telecommunication service. And what does that mean to all of us, and what does that mean with respect to regulation and fairness and cross obligations? Again, so we'll talk a little bit about that and then go into great detail with Ken and Brian. And then the other thing that's happened is we're seeing this explosive growth in wireless services. And what is happening is that as they explode in both demand and in new technologies, we're shrinking cells. And as you shrink the cells, it's driving deployment nearer and nearer to the end user, and that means nearer and nearer to our rights of way. And you can get this presentation from Tanya, and I just threw some charts in the bottom there to sort of try to justify that idea of explosive growth. I think that there are two resulting challenges. One, for local governments to ensure, or local communities to ensure, that they're receiving a fair rent. And so the question is, what do you do when you have a cable franchise that only compensates you based upon cable services, when that same infrastructure is being used increasingly to provide things that are other than cable services, and may soon be providing wireless services over that same infrastructure? So what do you do, and how do you go about doing with that? Again, as the portion of the programming that's paying rent is reduced, and the portion that's not increases, and what can you do there? And then what about protecting local control? So as we have this growing number of wireless providers, or hybrid wire and wireless providers right now, so there we're talking about DAS providers that and small cells, people that are both sort of wireless in their technology but also incorporate a great deal of fiber or wire in their program. How do you deal with them, and what are the various rules that apply when it comes to their access to the rights of way? Now, again, I don't think I'm about to say anything different, but just it's rephrasing these questions again and giving examples. So the questions that we're all being faced with: what entities have access to the rights of way, and under what terms? Like, for instance, entities that are providing DAS or small cell installations, what are their rights? And we're seeing litigation today in Texas and Pennsylvania and elsewhere about that legal status. So what is and how is it defined? What does the right of access allow an entity to do? So for instance, we just talked about it. Does a cable franchisee have the right to provide telecom services, to also then to take their infrastructure and convert it to a wireless infrastructure? Those types of questions. What conditions and fees can be imposed to allow us, again, with fairness, and we'll talk about fairness. And then the related issue is what taxes can be imposed on the service provider and others that are in the rights of way. So we have a whole bunch of questions, and now the questions are, well, what are the rules? What are the guidance? Well, the biggie for a wire line is 253, right? 253A says that we cannot prohibit or have the effect of prohibiting the ability of any entity to provide any interstate or intrastate telecommunications. But then there are a couple of safe harbors. There's a safe harbor in B for the states and a safe harbor in C for local governments that say, even if the rule is prohibitory, it's not preempted if, and I'll focus on ours, 253C, the requirement relates to rights of way management or reasonable compensation on a competitively neutral and non-discriminatory basis for use of the public rights of way, again, on a non-discriminatory basis, and that compensation is publicly disclosed. So again, the rules sort of give with one hand and take away with the other, or in this case, take away with one hand but then replace with the other. And so that's out there. But a rule that we haven't seen in a while, or it's been there for a while, but I don't think we've ever talked about it, or at least the second half of it, is Section 541. That's the cable franchise obligation, right? So it says right up front, a cable operator may not provide cable service without a franchise. But if you go to the second half of it, and I've tried to reproduce it here, it does say that if a cable operator or an affiliated is engaged in the provision of telecommunication services, they shall not be required to obtain a franchise under this chapter. That is, under the cable. Doesn't mean that they don't have to get a telecom franchise, but they don't have to get another cable franchise. And it says that the provisions of the chapter shall not apply to any such cable operator or affiliate for the provision of telecommunication services. So what Congress said is that you can have a cable franchise, but it doesn't apply to telecom services. Oh, and by the way, if you look at C, it says that you can't require that either they discontinue or that they provide a service. So I think we're going to come to understand 541 a whole lot more as time goes on and trying to figure out what we can and can't do, and I look forward to our discussions on that. There's another thing, too. In the Open Internet order, there was a footnote 1285, and in it the Commission says, and we can debate whether or not this is dispositive, whether or not this is dicta in sort of the idea that it wasn't necessary for the ruling, but and it's not clear that it was a footnote that everyone truly understood it, but it says that we do not believe that the classification decision made in here, and that is that it's a telecom service, would serve as a justification for a state or local franchising authority to require a party with a franchise to operate a cable system to obtain an additional or modified franchise in connection with the provision of broadband internet access service, or to pay any new franchising fees in connection with the provision of such services. I don't know that I agree with that. I know I don't agree with it, but again, it's out there, and I think people need to sort of consider that as you move forward. One of the important cases that's out there right now is the City of Eugene versus Comcast, and I think the bottom line there was that the court rejected the claim that the cable franchise in itself prevented the locality from imposing a fee for use of the rights-of-way to provide internet. And under the Oregon rules, they were able to provide. They had a telecom franchise fee in place, and they were able to enforce it. And again, I think that that's something that we can talk more about, but it's something important to know. So we sort of talked about what the wireline rules are for the rights-of-way, but let's talk about the wireless rules, right? Because we're talking about this great challenge of the hybrid systems, both wired and wireless coming in. And there's section of 332C7, and again, that applies to all personal wireless service facilities, and generally it preserves the authority of local governments to control the placement of personal wireless facilities subject to certain substantive and procedural limits. There's 5 of them, and we can talk about those later, but in the interest of time, we'll move on. And then that was supplemented by the middle class tax relief. That's section 1455. This is or some of us call this the 6409. This is the sort of the fast track for co-locations that do not substantially change the site. And again, so it applies to all wireless applications. Please note that's broader than 332, and it preempts local discretion over certain co-locations and modifications to existing wireless sites. And I would recommend a program that Trip and I did. Trip did a terrific did a terrific job on Anina Tella walking us through sort of that. And then there's the FCC regulations that have to do with all this across the board, the establishment of shot clocks, et cetera. But when we're talking about wireless deployments in the rights-of-way, again, we got to come back to Section 253, and there's some thought that maybe a section of 332 sort of prohibits the application of 253 to applications. It seems to say that, but again, something that you need to be aware of, and it will be applied. And again, it's the idea that when you have a hybrid structure, then you sort of got a hybrid regulatory or statutory oversight. So for the wires, there's 253, and for the wireless, it's 332 as modified by 6409, and people need to keep that in mind and be ready to move forward and to address all of those. And then again, to understand what the remedies are under Section 253, remember that the FCC gets to preempt rules that create barriers. That is, they get to look at 253A, but they do not get to modify or rule on things under 253C, something that has to do with compensation or something that has to do with the management of the rights-of-way. Those go to the courts. The aggrieved parties must sue under 1983 and or may sue under 1983, but it goes to the federal district court. And so the whole question is, if Section 253 applies, what does non-discrimination require? And again, we're seeing litigation in this area. There was a case in Virginia which addressed that same issue, saying, why are you asking some wireline utilities to do X and others to do X plus 5? and the court there decided that under Virginia law and didn't reach the issue of 253. And I've got a compendium of cases at the end, and you can find that in there. And then the other thing is, and this is where Ken's going to take us, but my last issue is going to be talking about the regulatory framework within each individual state and their rights of way use. And they vary tremendously. And again, this is Ken's area. I'm just teeing this up to also say that there's also a tremendous variation in what we can charge. And I give you some examples, but the reason that I have this in here is for this next chart, which is simply to say that one of the most complicated things to do, and this is from a presentation that I did in Georgia a couple of weeks ago, one of the most complicated things to do is to understand that not only are there the federal rules, but there are the state rules, and you need to make sure that you understand what all the various benchmarks, what all the shot clocks are in both proceedings, and you marry them together to make sure that your team doesn't blow deadlines. Again, this is 4651 is sort of the rights of way, the equivalent of 253 in Georgia law, and it talks about within 60 calendar days, you get 15 business days to determine if it's been completed, and 60 days in which if you haven't acted, then it's considered complete. So this is in addition to, the shot clocks for under 332 and 6409. So again, no real answers here, just caveats to let folks know that you really need to know what your time frames are across the board. I'm not going to speak to the rest of this, but I've got about 5 pages that go through different recent cases in this area and that people can look at. I want to give credit to my colleague Joe Van Eaton and Trip May. The three of us did a presentation, and this is lifted right from there. It doesn't include the San Francisco case that Bill just walked us through. I actually did include it. I took it out because I didn't want to take a chance of having anything in there that was inconsistent with what Bill was saying. So that's where it is for me. Let me get out of the road. I apologize if I've taken too long, and I know that I went too fast, but that was my promise to everybody that I would. So I guess I'm handing it over to Ken Feldman.
All right, thanks, Jerry. Let's see. All right, hopefully my screen is up there now.
Perfect.
And Tanya and I have been emailing back and forth because I've had I've been cut off by this call a couple of times. So hopefully it won't happen in the middle of my presentation here. But I'm going to start by talking about and focus most of my talk on state law issues. And if I can get my computer to actually advance, we would be able to do that. There we go. Jerry talked about how do you protect fair rent, and I'll start by saying in some cases, and perhaps in many cases, you can't, because we are limited by our state statutes as to what compensation we receive today. So even in some states where local cable franchising still exists, you may not be able to charge rent for other kinds of communications uses of the rights of way. The states that preempt all franchising authority for telecommunication services in the rights of way, some states that restrict franchising authority, allow franchises, but restrict certain kinds of franchise impositions in particular fees. And some are silent on it, and I'm going to use a couple of examples here to talk in a little bit more detail. So in Colorado, we have a state statute that basically preempts any franchising by local governments of telecommunications providers of any kind except for cable television. And there's a long, boring story for how the cable exclusion got put in the statute, but basically this was a statute that was passed in '96, the same year as the Telecom Act on the federal level. At the time, everybody had a cable franchise and was generating revenue, and nobody, well, very few folks anticipated what the future of communications were going to look like and the impacts on the rights of way. And I think our legislature, with a lot of help from the industry, understood that If they tried to take away cable franchising, they'd have every mayor in the state down there screaming about loss of revenue, but maybe they should just focus on preempting everything else because no one was wise to that yet, and that's what they did. So we've got a statute that basically preserves local police powers. It allows limited recovery of fees and I've got an exact quote there, you can recover fees for providing services related to the granting or administration of permits. For a number of years, local governments thought that meant any kind of real, actual cost recovery, full cost recovery, including degradation fees. And as we know, anytime you cut the pavement, you're degrading the life of that street and shortening the period of time before you're going to have to overlay it. And a lot of communities were charging for that kind of street degradation costs. We've since had case law that has said, no, the legislature said the cost of providing services related to the granting of permits, that's the folks behind the counter. What's their hourly rate? Or the people who go out in the field and do the inspections. You got a degradation fee? Can't charge it. And the court even said, we recognize that is less than full actual cost recovery, but that's what the legislature said, and that's what you get. So, you know, that's an example here in Colorado that it's hard to preserve fair rent because we're not allowed to get it now. Now, another example is the state of Washington. They've got a couple of different statutes, one relating to municipalities, another one that I'll get to in a minute relating to counties. The municipal statute allows for what they call master permits, and in that statute there are, I didn't get into this in great detail, but just know that there's a lot of different prohibitions of many of the kinds of things that we often see in our franchises, but it does allow for certain things that we would put in a franchise, like joint trenching. But even there, it prohibits, if a municipality requires joint trenching, that the municipality can't use that joint trench for providing telecom services outside of its own uses. So as far as municipal broadband projects, you've got a problem there. And then there's another chapter in Chapter 80 in the statute that allows for franchises for telecommunications, but there's no reference either yes you can or no you can't impose franchise fees. Then we have a county statute in Washington that specifically does authorize franchises for the use of rights-of-way for telephone, telegraph, so you can tell when that statute was written, and any other such facilities. But again, no specific reference to franchise fees. I've had discussions with city attorneys and county attorneys in multiple local governments in Washington, and we always try to find a way to find some authorization or some legal argument to say yes, we can impose fees here. And but the bottom line is, it's you know, at best it's a crapshoot because you just can't find a specific direct authorization. Interestingly, in both of these statutes in Washington State, and your state may also have similar language, there are provisions that allow for the preservation of existing franchises. So many communities have very old franchises with the old incumbent telephone companies, which also may not have provisions for franchise fees, and there's also constitutional language in many states about the, you know, 100 years ago, the original telephone company, and those kinds of agreements may in fact limit what can be done with competitors today for some of the reasons that Jerry pointed out in Section 253 and the need to treat people on a competitively neutral and non-discriminatory basis. I want to make one further point on this slide here, and many of you have either been at NATOA conferences or participated on other eNATOAs or other webinars talking about the future of cable franchising. So a lot of us are looking at, in those areas where we can franchise cable, and we are receiving rent at least for the provision of cable service, is that going away? And depending upon who you talk to, yes, it's going away. No, it's not going away. Yeah, it's going away in 5 years. It's going away in 10 years. At some point, everything is going to be over the top, and cable service, as it is now defined in federal law, will not be the service that is being, the video service that's being provided. So it's really critical that you understand your state law, and you start thinking about, if cable goes away, does my revenue go away? And in many cases, the answer is yes. So the next question is, how do we replace that? And it's tough, because there may not be a way under your existing legislative framework to recover that. So while I'm focusing here mostly on state law, I will remind you that we keep hearing about, at some point, there's going to be a rewrite of the Federal Act. And NTOA has the blueprint for future of telecommunications regulation. And is there really going to be, in some rewrite, a right to recover a franchise fee or comparable consideration for any kind of physical occupation of public rights-of-way for telecom infrastructure? There ought to be, but we all, I think, have discussed that's going to be an uphill battle for us, but we need to keep an eye on that and keep focused on it. I want to talk briefly just about some of the new challenges that Jerry alluded to with wireless facilities in the rights-of-way. This is a photograph of a beautiful new mobility pole that someone from Mobility sent me just the other day. Many of us are seeing the demand for access to the rights-of-way for wireless facilities. And as to the question, can you require a franchise? Again, it's a function of your state law, and that is where you need to look first. And if you can't franchise these assets in the right-of-way, then as an alternative way of looking at compensation, look at the vertical assets that you may own in the rights-of-way, traffic signals, possibly streetlights, and those you can rent as opposed to requiring a franchise, which is more of a regulatory contractual document for the use of the rights-of-way. This would be an attachment to an existing local government-owned vertical asset, and it's an alternative way to generate fair compensation for the use of public property. So I would encourage you to look at that. I guess my last point on this is, and it gets back to, again, what Jerry talked about, this Section 332 control, the Section 253 control. What do some of these cases say about what does it mean to be non-discriminatory? I think it's fair to say that we don't have clear law yet in every jurisdiction on this. So whether the first company that is putting pressure on you to put facilities in the rights-of-way is Mobility or Verizon Wireless or AT&T, it doesn't matter. However you deal with the first company, and whether you end up granting a franchise or whether you license them, however you deal with it, whatever conditions you place upon it may very well impact how you're going to deal with subsequent companies. And the one thing we can be pretty sure of, regardless of who's knocking on your door today, there will be more folks knocking on your door tomorrow. So I will leave it there, turn it over to Brian. He's going to give us some examples also of things that he's been working on in this area, and then we will have some questions. Thank you.
I have to say I have never been involved in a presentation with 3 attorneys where we actually leave 25 minutes left for the final speaker. That's got to be a record of some sort. So
because you're going to answer all the questions. Ken and I agreed you'd answer everything. You'd clear it up.
Wouldn't that be nice? Well, when we spoke about this in advance, trying to figure out who was going to cover what aspect of this topic, one thing I volunteered to do was to describe what I'm seeing kind of out in the field. And I'll be honest in saying these comments that I'm going to make probably don't apply to Chicago and New York, Boston, San Francisco, cities where you have teams of folks focused on right-of-way control and revamping regulations on a very regular basis. A lot of the calls that I get are from more the mid-sized, smaller-sized communities around the country, and they're caught off guard a little bit by what's hitting them these days with some of the issues that Jerry and Ken described. And when I go into their code and look at their right-of-way provisions, some of them haven't been touched in 25, 30 years. And they were drafted in an era where we had, the basic utility companies using the streets. A lot has changed since then. And really what the first issue that some of these folks have to get their arms around is how to convince the mayor, the city council, and others to spend a little time and effort trying to revise their code so that they're better prepared to deal with these companies as they come forward. And so feel free to steal some of these slides to the extent you're trying to go through that kind of discussion with elected officials. But let's start down at the 6th grade level for a minute here. A right-of-way is just a legal right to pass through property that's owned by another. In this case, we're talking about municipal rights of way. So you have to balance the multiple demands on the same property. And throughout this conversation, what I'm focused on here is I'd like you to think about governing and regulating the right-of-way, not the provider. So forget about what kind of company it is that's coming into the streets. Now, that's all with due respect to the various cases and statutory references that our prior speakers gave. Those, of course, we have to pay attention to. But think about this in terms of, I have a right-of-way, I've got to regulate it. If you do it that way, as opposed to company-specific regulations, you're going to be in a much better position to defend those regulations as non-discriminatory. So how do we use this right-of-way? And again, maybe my presentation could have gone first because some of this is rather basic, but we use it for all of these various purposes. Transportation, communications, economic development, and all of these things that are listed under the accommodations are ways in which we use our right-of-way. The problem is, in most cases, your code provisions that you look at were drafted, or at least for many of you, were drafted in an era when you were just dealing with gas, electric, water, maybe telecom over the top. And then we started to see cable come in, and we didn't know what to do with them, so we franchised them, and we put all the regulations dealing with cable into a separate franchise, and we never actually amended the city code to address some of these new kind of non-regulated providers. So that's the problem that a lot of the cities are facing. Who's using it today? It's the same gas, electric, water, telephone, cable, but now, as you've heard from the prior discussion, it's cellular providers. It's CLECs, and most of you know those competitive local exchange carriers. In many cases, folks that are wholesaling what Verizon, AT&T, and CenturyLink are providing, but in other cases, they're putting in their own facilities, their own dedicated lines to some of the major employers in town. You've got backhaul providers that are putting fiber in from the macro cell sites, carrying the signals back to a central office. You've got something called a carrier's carrier. As Ken alluded to, that's the mobilities of the world. People that are coming in, putting things out into the right-of-way, they don't actually provide a service themselves in many cases, but what they're doing is they're trying to sell their facilities to the actual telecom providers. You've got folks that are just putting in fiber for broadband, point-to-point fiber, and then 100 variations of everything I just mentioned. All of those folks are in your right-of-way, and in many cases you don't even know they're in your right-of-way. And so kind of the key slide, I think, in my presentation is setting up some goals that you can use to drive your code revision on. And so, the idea that you want to convince your mayor and your council of is, look, we need some policies to manage this. We certainly have to have it in a fair, reasonable, non-discriminatory manner. And then, of course, we've got to be able to address cost. And if not cost recovery, if your state is one that allows you to receive fair and reasonable compensation, then you've got to try to impose those regulations in a way in which you're not going to, again, discriminate against one company over another. And that gets to be particularly tricky if, for example, you're in the southern United States where AT&T, at least in a half-dozen states, claims that they're subject to a 100-year-old exemption that allows them to use the right-of-way free of charge. Can you impose fees on other right-of-way users if AT&T gets to ride free in those same streets? Those questions are going to be state-specific in each case. And again, the final point, or the point that I made at the top of this presentation is anything that you do in your right-of-way, think of it again as governing the right-of-way, not the company-specific. You're going to be in a far better position as you craft your regulations if you do that. I think 3 questions that you want to ask, particularly if you're asking yourself, Do I need to revise my city code? First of all, do you know who's working in your right-of-way? All of the various companies that Jerry, Ken, and I have all referenced, do you know and do you have an inventory of who's out there in your streets? Can you pull out and put on a piece of paper how many different licenses, franchises, separate agreements that you have, dedicated easements, other things that you have with either the provider or perhaps with one of their subcontractors, and can you provide that inventory? If there's companies that are out soliciting business in your city and you don't have them on your inventory list, then that means they're in your right-of-way and you don't know where they are because you don't have any authority, or they don't have any authority to be there. For the companies that are in your right-of-way, are they actually familiar with what your city code requires? Permitting, notification, safety, all of the standard things. In many cases, what I have found certainly is, even in cases where we have a reasonably updated code, most of the providers have largely been ignoring the requirement to go in and pull the proper permits and comply with the proper code provisions, at least in cases where they're doing not a serious construction project, but rather one-off construction projects. They're simply going out and doing it and never asking permission from the city. And then, of course, the third big issue, which I think both Jerry and Ken alluded to in detail, is the city being properly compensated? And we keep saying that's a state-specific issue. I know if we had much more time, we could start trying to go down a handful of states and list off what we know about their various laws. Jerry just mentioned Georgia, for example. I've done some work down there as well. But, for the benefit of the callers on this call, we can't go through a 50-state survey of what each state's requirements are. It's enough to say, as Ken mentioned, you need to really dig into what the law in your community permits. I have seen everything from percentage of gross, even on access line fees. Certainly we know that on the cable TV side. There are states that have a linear foot charge. Georgia's one of them. I think in that case it's $5,000 a mile. I know that there's plenty of communities on the West Coast that are doing linear foot charges. And then there's states like my own in Minnesota where we're limited to a cost recovery on all things but for cable TV. So really varies dramatically state by state. When you think about your code, again, as I mentioned, we're always thinking about the historical users. Keep in mind, too, that the private users that you have in your right-of-way, whether it was telephone, cable, or other companies, almost always had separate franchise agreements. Think back to the days in the mid-'80s, '90s, where you had 100-page franchise agreements in many of these communities. Now you have a state law comes in, takes away that cable franchise, and gives authority to a company with a one-page application at the state level. What happens to all of those regulations that typically were burned into that local franchise? Did the city go back and capture them through amendments to the code? Or do you now have companies out there using the right-of-way that really aren't subject to any franchise requirements, and because the code was never updated, kind of have a free rein to do as they please in the streets? I think Jerry mentioned earlier on, if you have authority to be in the street because you are, for example, a cable TV provider, does that then mean that you can put in any ancillary facilities into that right-of-way, into those utility easements to support broadband, telephone, wireless, who knows what kind of communication service? Can you ride all of those services on that one authorization? This is where, if you have a city code provision that requires certain permitting requirements, certain inspections, verification of what's being put in the street, that allows you then to keep that inventory and try to create a non-discriminatory approach to how you're regulating that right-of-way. Leaving time sufficient for questions, I'm going to go through a little bit coming up here on what the FCC allows us to do and not to do. There's some dispute about whether the FCC really can prescribe some of these things, and I'll cite a few cases here coming up. But among the things the FCC has stated are supportable right-of-way provisions would include coordination of construction schedules, determination of insurance, indemnification, establishment and enforcement of building codes, system monitoring to prevent interference between the various users. Obviously, you can require certain things with respect to undergrounding, And including on undergrounding, you can discuss issues about where you may be dedicating above ground facilities to be going underground and dealing with the cost of whether you're reimbursing the above ground providers for that obligation to move their facilities underground. You can also regulate time and location of excavation for all of these, public health, safety, and welfare considerations. And then when you get into the fee issue, the FCC themselves recognized the ability to recover costs related to street repair, et cetera, and even the lost value of breaking up a right-of-way. And whether you can get fair and reasonable rent, really, again, is going to vary state by state. And of course, you can always enforce your zoning regulations. Some of that now, of course, subject to what some of Jerry's comments were with respect to the cell site rules that the FCC has come out with. Some of the things the FCC talked about that were unacceptable right-of-way provisions, and these have in some cases been tried out in various cases that I tried to cite for you here, requiring another layer of adding proof of financial, technical, legal qualifications. In many cases, the FCC concluded that that was something that the states are already doing at the utility commission level, or it's occurring at the FCC level, and that duplicating that as a third layer was not appropriate in the FCC's mind. A description of what kind of precise telecommunication services would be provided in order to gain access to the right-of-way, regulation of stock transfers. Some cities were trying to impose requirements of most favored community status, and the idea that trying to say you will pay for in my community the maximum rates and the most favorable terms that you've agreed to anywhere else in the state, and then various unspecified franchise terms where you would retain the ability to revoke right-of-way authority for unnamed factors. And all of those, in those cases that are cited there, kind of spoke more specifically about these various FCC prohibitions on right-of-way control. A couple of final comments about the Section 253 that Jerry in particular spoke about. We have this 253A, what we're all looking at to say, is there a violation? But let's talk about the burden on that. The burden here is if a provider believes that there's been a violation of 253A, they have to prove up an explicit prohibition or the practical effect of prohibiting their ability to get into the city and provide their telecommunications service. If they can demonstrate that and meet that burden, that they have been prohibited from getting into your streets because of your right-of-way regulation, then you have the ability to exercise your safe harbor exception, primarily under 253C, and you can go forward and try to defend yours using that safe harbor. They've tried to, the FCC, establish certain criteria related to what they mean by an effective prohibition. Clearly, if you just say nobody gets into my streets, that's a prohibition. But what does the effective prohibition mean? And the FCC, at least in some of their materials, have argued that it's a material increase in costs without necessity or materially inhibits a fair and balanced environment. Those are cases or FCC proceedings where that issue was reviewed, but this effective prohibition is one that's very ambiguous. It's in a gray area, and as you look at various right-of-way, you're certainly going to have operators raise this argument, and then it's up to the city to closely review and determine whether you've exceeded your authority or whether you have the ability to impose that without essentially prohibiting that provider from being able to come into the right-of-way. 253C, as it relates to the fair and reasonable compensation, I'm not going to go too far into this, again, because it varies so much state by state. There is a real split among the various courts around the country in terms of what is fair and reasonable and what fees that a city may be able to impose. The telecom providers, of course, always want to argue that compensation is simply cost-based recovery, and the cities, of course, are looking to try to increase that to be able to obtain rent for the fair use of the city's rights of way. But as I've said maybe 6 times, and the other speakers have also mentioned, everything is going to vary state by state. So in conclusion, You know, again, when my phone rings, it's usually the question of, hey, we've got all of these folks knocking on our door to get in our streets. Our code seems rather lacking in terms of our ability to impose any reasonable regulations. So as you look at your code, you know, you don't want to put in restrictions that are going to drive some of these competitors away. I think we all recognize the benefit that some of these communications providers will afford your community, and in a lot of cases drive your economic development. So you want to take a look at it and make sure that you're putting in regulations that specifically address right-of-way usage, that aren't company specific. And then, of course, if you have the ability to impose compensation, you can do so in a fair and reasonable manner that's applied non-discriminatorily to all of these various right-of-way users. So with that, I think I've left the allotted amount for Q&A. I'll turn it back to our moderator.
Okay, thanks, Brian and Jerry and Ken for those presentations. While we're waiting for the questions, I think Ken had a further comment he wanted to add. Ken?
Yeah, Brian, thanks. One of the things I wanted to mention and forgot to during my presentation as it relates to cable, for those of us who have dealt with cable franchises in communities where it's either prohibited or it's not clear about telecom franchises, for years we have dealt with what have become standard language that says this is a cable franchise. It is neither a grant of a authorization to provide telecommunications or a prohibition of that. It sort of kicks that can down the road. And again, and I'm interested in particularly whether Jerry and Brian have dealt with this, but you know, we have this standard language that we've become used to, and this sort of points out why it's really important every time you start a new agreement to check the language. Last month, for the first time after years of having that kind of standard language in a franchise, I got a cable operator's language that says it doesn't authorize the grantee to provide telecom service, to construct, operate, or maintain telecommunications facilities, and then these new magic words, separate from those used to provide cable services, which to me is a clear implication that this is a grant to provide telecom services if you're using the same infrastructure that you use to provide cable, which is clearly not the intent of the local government who's sitting at the table trying to negotiate a cable franchise. So I raise that just to give you all a caution and a heads up that if you're in one of those communities where there, you know, maybe some franchise authority for telecom and you're negotiating a cable franchise, or even where there's no authority to grant a telecom franchise, but the law might change in the future, make sure your cable franchises do not inadvertently grant a telecom franchise at the same time, and then you will be faced in the future with some argument that, well, you guys agreed we only have to pay franchise fees on the cable side of the book and not the telecom side. So
at least your guy was sophisticated, Ken. Your guy was sophisticated. I had somebody send me back yesterday, on Friday, pardon me, edits in the grant of authority. And so it's not only the right to own, construct, operate, and maintain a cable system, but they want to insert and cable communication system. And then at the end they say grantee may provide non-cable service over its cable system provided such services are not prohibited by federal or state law. So some of them are being even a little bit heavier handed. Obviously we laugh and smile because again, while we can't require that they give us perhaps certain other requirements, it's pretty clear that all we have to do in the grant of authority is to permit them to construct and maintain a cable system for the purposes of providing cable services. I agree.
Right. And so the takeaway is we're talking, the topic of this webinar is right-of-way control and compensation. And if you're doing that in a cable franchise, make sure you're limiting it to a cable franchise and whatever authority you may have now or in the future for other kinds of uses of the rights-of-way, even if it's going over the same darn wire as the cable service, that you protect your jurisdiction's ability to exercise that authority when and if you choose to do so.
Okay. Thanks. Before we haven't got any questions. There was one comment that I'll get to in just a moment, but I did want to make an announcement about future ENATOAs and then allow our panelists to have a final statement. I think we'll go in reverse order, starting with Brian Grogan. But on November 14th, we're having another ENATOA on best practices for video production, and then on December 12th, we have the courts, the Hill, and the FCC a year in review and setting the stage for 2017. So those are upcoming ENATOAs. And the observation, which I'll leave without comment, was that it looked an awful lot like Ken's picture of the mobility pole, had the pole in the middle of the sidewalk. And I think that was confirmed by a closer examination of that picture. But
yes,
for a final...
well, Brian, I would just mention I did take a closer look at that when I saw that comment, and indeed, it is right in the middle of the sidewalk, which led me to wonder whether it was across the street from Jonathan Kramer's house.
So for a final comment, maybe we'll start with Brian Grogan.
Sure. Well, I guess I would just say, chiming off of that one issue, it reminds me of a brief case I had here in the upper Midwest where mobility came in seeking 6 different poles of substantial height, one of which was to be placed in the middle of a sidewalk. And this happened to be one of those communities that had a woefully inadequate set of code requirements to deal with the issue. Fortunately, there was some confusion about whether the company actually had appropriate authorization from the state, so we were able to deal with those applications. But in the meantime, the city had to scramble and actually look at their code and say, what is the appropriate level of regulations to apply across the board to all of these various users, not just targeting one particular company. Maybe it's mobility, maybe it's somebody else, but really universally looking at it. And it was an opportunity for them to backfill a lot of areas that were in need of some updating. So try not to wait till the last minute. If you can, try to get out ahead of the curve, and I think that'll serve you well.
Great. Ken, any final thoughts?
I think we've said about as much as we can say about this, so I will just wish everyone a happy end of the election season, because I'm sure we all can't wait for it to end.
Jerry?
I don't know if I can top that, but 2 quick things. One, Ken and Brian and I all talked about the various rules at the state level. If you don't know what your rules are, ask your city attorney, your county attorney, or if you want to get a starting point, NTIA a number of years ago did a collection of all the various state laws with respect to rights-of-way management and compensation, and that's there on the NTIA site, and that might give you a start. And then the last thing is sort of a semi-commercial for NATOA. Steve and Tanya have recently sent out a reminder to all of us that if you had a great time in Austin, and I did, 10/21 is the deadline, so it's the end of this week is the deadline for suggestions for what kind of programming you'd like to see next year. And so people should do that. That's an important deadline for the committee to figure out what it is that they need to do and speakers they need to get. That's it for me.
Okay, it looks like we do have a question, Brian.
It's just in. We got a question. What are restrictions that may apply if the county installs poles and then decides to lease the poles to others? In other words, the county becomes the carrier's carrier.
Yeah, that's a really, really good question, and it's something that a lot of folks are thinking about. There's a paper that's being circulated right now that Susan Crawford wrote, sort of highlighting a Southern California community that's doing just that. I think the real question, and I'll defer to Ken and to Brian, I think the real challenge is to make sure that somehow it's not exclusive, because right now I think it would be tough to overcome a 253A limitation if you said that people had to use that pole. you know, even if other sites were available. I think it's sort of that exclusivity. The exclusivity many times that makes the thing worthwhile, or from a policy standpoint or a financial standpoint. But there's a matter of, it was called Minnesota DOT, where they tried to put a fiber optic ring in their the state highway rights of way, and they asked the commission before they did it, would that violate it if it was exclusive, and the commission seemed to indicate that yeah, probably would. So I think it's, but just try not to make it exclusive, because that could jam me up.
This is Brian. I think Jerry nailed that. I mean, I think that's the key issue. Is it's true in so many different aspects on the telecom side. If you say it's my city conduit, it's my water tower, it's my utility pole, or it's the highway, you don't get to get into the city, I think you have a real 253 issue.
Right, and the only thing I would add to that, other than to say I agree with what both Jerry and Brian have said, is if the county wants to do that, be careful about the what heights you're going to use and how you're going to install these. Because if you have zoning height limitations and you've got residential areas and there are 35-foot height limitation, but you decide that for your wireless network on the rights of way you're going to put in county poles that are 60 feet tall, the next company that comes in and wants to put in a 60-foot pole, you're not going to be able to say our zoning height limitation are 35 feet if you violated that yourself. So to the extent that you want to stick with your zoning height limitations, put in your own network, but play by the same set of rules that you're going to impose on everybody else.
Okay, thank you. I don't know how much more time we have. We did get a San Francisco question. Please explain the San Francisco formula RE street cutting.
Is that the street damage restoration fee they're talking about?
I think so.
Well, it's a very complicated formula. Then we don't use it anymore because we got sued by PG&E over
That's our electric utility here.
claiming that it violated their franchise, and we lost that case. So we stopped enforcing that ordinance because PG&E was the major person who had to pay those fees, because they do more excavation here than anybody else. But we did Brian, you were here, right? We did a very complicated study to determine how much we could charge for street degradation.
It was a fantastic study, but in the late 90s. But again, since it's fallen into abeyance, I think we'd be happy to distribute that if we can dust it off. But you can just contact me directly. Well, thank you to our panelists, Ken Fellman, Jerry Lederer, and Brian Grogan. Really appreciate